5 seconds to go. Start. Before tendering the minutes of order to the court, the advocates must consider whether an order, if passed by the court in terms of the minutes of order, would be lawful. After minutes of order is tendered before the court, it is the duty of the court to decide whether an order passed in terms of the minutes of order would be lawful. The court must apply its mind whether the parties who are likely to be affected by an order in terms of the minutes of order have been impleaded to the proceedings. If the court is of the view that an order made in terms of the minutes of order tendered by the advocates will not be lawful, the court should decline to pass an order in terms of the minutes of order, and if the court finds that all the parties likely to be affected by an order in terms of the minutes of order are not parties to the proceedings, the court will be well advised to defer passing of the order till all the necessary parties are impleaded to the proceedings. In the facts of the case, the senior district level officials of the state had stated on oath that the construction of the compound wall, in respect of which relief was sought in the writ petition, would affect the rights of several third parties. However, the court completely ignored the same. Even in clause 6 third of the minutes of order, there was enough indication that the compound wall, if not appropriately constructed, would affect the rights of owners of the other lands. Therefore, it was the duty of the court to have called upon the first and second respondents to implead the persons who were likely to be affected. The first and second respondents could not have pleaded ignorance about the names of the concerned parties, as they have referred to the owners of the other lands in the minutes of order. However, the division bench of the High Court has failed to make even an elementary inquiry whether third parties will be affected by the construction of the compound wall under police protection. Hence, the order dated 16th March 2022, passed in the writ petition in terms of the minutes of order, is entirely illegal and must be set aside. The writ petition will have to be remanded to the High Court to decide the same in accordance with the law. The construction of the compound wall is complete, therefore, while remanding the writ petition to the High Court, we must clarify that the construction will be subject to the final decision in the writ petition. After remand, the High Court will have to call upon the first and second respondents to implead necessary parties to the petition. If required, the court must decide who the necessary parties to the petition are. It will always be open for the appellants to apply for impleadment. While determining who the necessary and proper parties are, the appellant's application will have to be considered by the High Court. It follows that on the failure of the first and second respondents herein to implead the necessary parties, the High Court will be well within its power to dismiss the writ petition and pass an order of restoration of status quo ante by directing demolition of the compound wall. Hence, we pass the following order. We set aside the order dated 16th March 2022 in writ petition number 2584 of 2022 and the order dated 20th July 2023 in the review petition and restore writ petition number 2584 of 2022 to the file of the High Court. We direct the Registrar Judicial of the Bombay High Court to list the restored writ petition before the roster bench on the first day of reopening of the court after the ensuing summer vacation. The parties to the appeal shall appear before the court on that day, as they will not be entitled to any further notice of the writ petition. Stop.